Under the National Stolen Property Act, or NSPA, a person is prohibited from transporting, transmitting, or transferring across state lines goods, wares, or merchandise worth $5,000 or more that the person knows was stolen or taken by fraud. In the 2012 case, United States v. Aleynikov, the Second Circuit considered whether the NSPA applied to the theft of intangible property in the form of a proprietary computer source code. From May of 2007 until June of 2009, Sergey Aleynikov worked as a computer programmer for Goldman Sachs. In his position, Aleynikov developed computer source code for the company's electronic trading system. Under Goldman Sachs's confidentiality policy, Aleynikov was required to keep all the company's proprietary information, including any intellectual property he created, confidential. Further, he couldn't take or use any intellectual property he created when his employment ended. In April of 2009, Aleynikov accepted a new position as an executive vice president at a startup company that was looking to develop its own electronic trading system. On his last day at Goldman Sachs, Aleynikov encrypted and uploaded to a server in Germany more than 500,000 lines of source code that he'd written while at Goldman Sachs. He then downloaded the source code to his home computer and transferred it to a flash drive and laptop. 1 month later, when Aleynikov returned home from traveling to another state with the flash drive and laptop, he was arrested by the Federal Bureau of Investigation, or FBI. Subsequently, Aleynikov was indicted in federal district court for violating the NSPA. In response, Aleynikov moved to dismiss the indictment for failure to state an offense. Specifically, he argued that the stolen source code didn't constitute goods under the NSPA because it was intangible intellectual property. The court denied the motion, concluding that although the source code was intangible, it still constituted goods within the meaning of the NSPA. Following trial, the jury convicted Aleynikov. Aleynikov appealed to the Second Circuit.